Trump administration seeks Supreme Court intervention in agency head firing dispute. In a significant escalation of its efforts to reshape the federal government, the Trump administration has turned to the US Supreme Court to secure the dismissal of Hampton Dellinger, the head of the Office of Special Counsel. The move marks the administration's first major legal battle to reach the nation's highest judicial body since Donald Trump assumed office in January. Dellinger's legal challenge underscores broader concern about the integrity of government oversight mechanism. The Office of Special Counsel plays a crucial role in protecting whistleblowers who expose misconduct within federal agencies. It also investigates allegations of retaliation against such individuals and enforces the Hatch Act, a federal law that restricts political activities by government employees. In his lawsuit, Dellinger warned that the administration's action could have far-reaching consequences, stating the special counsel's ability to protect the civil service and investigate alleged misconduct is needed now more than ever. He further highlighted that in the past 3 weeks alone, an unprecedented number of federal employees with civil service protection have been terminated without cause. Judge Jackson, in her restraining order, expressed skepticism over the administration's legal position. She noted that Dellinger was likely to prevail in his case, as the attempt to remove him without citing any specific cause plainly contravenes the statutory protection afforded to the special counsel under federal law. She underscored that Congress has deliberately structured the OSC to be independent and insulated from political interference. Judicial roadblocks and potential Supreme Court precedent. The Trump administration's initial appeal was rejected by the U.S. Circuit Court of Appeals for the District of Columbia in a 2-1 decision, with the court ruling that the case was premature given that Jackson's order was only temporary. However, the administration remains determined to press its case before the Supreme Court. Should the nation's highest court take up the case, its ruling could set a significant precedent regarding the limits of presidential authority in dismissing heads of independent agencies. With the administration having already dismissed 17 inspectors general last month, officials tasked with investigating government malfeasance. This legal confrontation is being closely watched as a bellwether for the future of independent oversight bodies under the Trump presidency. The administration's approach to executive power has been characterized by an aggressive effort to remove official deemed obstacles to its agenda. Critics argue that these actions undermine the checks and balances system and erode mechanisms designed to ensure government accountability. As the case awaits possible Supreme Court review, legal scholars, civil service advocates, and political analysts continue to debate the implications of a ruling in favor of the administration. Such an outcome could potentially weaken the autonomy of agencies tasked with preventing government overreach, raising questions about the future of nonpartisan federal oversight in an era of deep political polarization. With the Supreme Court's decision pending, the case represents a pivotal moment that